Joining us now in the studio is Phoebe Haddon, who is the Dean of the University of Maryland's Francis King Carey School of Law. Thank you so much for being with us.
Thank you for asking me.
We asked you to talk about the Supreme Court ruling today on affirmative action. The headlines basically say that the court punted the issue. How do you see it?
Well, I think there's good news and there's bad news. The court did not find that the University of Texas discriminated against Abigail Fisher. The court did not overrule or change in any dramatic way the precedents related to affirmative action, the Grutter case, the Gratz case, and Bakke. And the court invited the Fifth Circuit, the court that had affirmed what University of Texas had done. It said that the court can go back and take another look at whether or not there is sufficient evidence. So we have in this case the good news that affirmative action is still alive and well, in the sense that it hasn't been overturned or questioned. On the other hand, this was a very narrow ruling, and it looked at the precedents in a way that suggested that it really is going to look more closely at how courts have scrutinized what is going on in an affirmative action case. And so in the case today, what the court said was that although the court appropriately deferred to the university in terms of a judgment that diversity is a compelling interest that can be served by using race as just one factor, it did not rule appropriately when it deferred to the university in terms of whether or not the particular program as implemented was narrowly tailored enough to serve the interest of diversity.
You wrote on this that the lower courts are going to be between the rock and a hard place in navigating that narrow area. What's the guidance from the Supreme Court?
Not much. It offered us a lot of good language in terms of the opportunity to have something like diversity as a compelling interest and the deference that's used when an institution is trying to promote diversity. But it also talked about the fact that these plans have to be very narrowly tailored. And so the strictness of the scrutiny is in question. How strict is strict scrutiny?
So they're sort of asking for gymnastics, if I'm hearing this right. The goal can be to have a diverse student body,
yes, but
you can't go overtly counting people, or you can't really have a quota system.
Yeah, you cannot have a quota system. That's not news. That was already developed in the University of Michigan Gratz case. The court has always been very much concerned that every individual has the opportunity to be evaluated on their own worth. And so you can use race as one factor under a diversity analysis that was promoted in the other Michigan case, the Grutter case. But you cannot, in effect, make race the only issue so that you don't get a chance to look at the value of the individual. And Texas did that. Texas did have a plan that very carefully looked at individuals. They used race as one factor. The problem is, according to the court, the Fifth Circuit and the lower court did not appropriately look at whether the plan was a plan that should survive because there was no other non-racial alternative.
The concern when they talk about non-racial alternatives, you read about programs where, I think it was a Texas program, where yes, you automatically accept to the state university the top 10% yes, of every high school yes, in the state, which sort of takes advantage of the unfortunate fact that there's de facto segregation in the high schools yes, around the state.
Yes. Now, that was a legislative effort to address some of the concerns that were remaining after the last case came up in Texas. And so one of the problems that the legislature addressed was that if you weren't allowed to use race as a significant factor, you would probably preclude very able individuals. So this 10% plan takes advantage, as you said, of the fact that we have racially segregated schools, and it prompted Justice Ginsburg to say that only an ostrich would think that that wasn't a race-based conclusion.
Just indirect.
Yeah.
Let me remind our viewers, if you have a question about affirmative action, the Supreme Court ruling, or what's happening at the law school, give us a call. We'll have the number up on the screen. Notable was Ginsburg's dissent was the only dissent. It was a 7-1 decision today. What do you make of that?
Justice Kagan didn't participate, by the way.
Right.
So I think that that's a very important point because the others concurred. Justice Thomas and Justice Scalia concurred with Kennedy, but Justice Kennedy, in a very narrow ruling, affirmed the underlying precedents that said the compelling state interest in diversity is still strong, and that institutions can come up with diversity rationale to which courts will defer. So that's a very important point.
What should students take away from this? I mean, either say you have a student, good student, member of a minority group, maybe first to go to college, who would like a leg up and you know, probably has experienced, at least indirectly, lingering after effects of racism, or the majority, non-minority student who's excelled and wants an equal shot at getting into the school.
Yeah, you know, I think that diversity is a very complex issue. We tend to focus on race, but diversity, as the court has described it, is much more robust and subtle than just using race. The problem is that diversity has become the only way we can use race as a factor in decision-making about access to education, as well as in other areas. And so I think we really have to educate people better about why diversity is a good value, but what are the complexities of those, and also to the reality that we don't have other opportunities to do service to this access issue other than diversity, because the court has struck many other avenues, such as you were talking about, prior history of discrimination. The court said institutions are not capable of doing that. Educational institutions are not able to do that. Legislatures can do that. Courts can do that. The other thing is that we have to think about what the other side might be. For example, if the court says that the Equal Protection Clause cannot justify the use of race, that means it becomes unconstitutional to use race. And it seems to me the result of that kind of ruling would be very, very, very much of concern as we move into a very multicultural and complex society.
Is that the justification for making diversity a priority, the fact that society is pretty diverse? I mean, how do you see that in terms of running a law school?
Yeah, I think that diversity is extremely important, not just for the question of access, but for the value that all students get in interacting with each other. And I can say that as a witness in classes and in situations where the community is diverse, because our law school has a very diverse population. And the interaction is extremely important, I think, for lawyers in particular, who will be serving clients of all races and ethnicities and complexities, not in connection with race at all. So I value diversity from that standpoint. As I said, I think it's important for us to understand that it is a complex issue, and that we ought to discover ways that can better promote diversity than only using race, certainly, but that race has to be part of it, because race is such a salient part of how we interact. I guess one other thing I'd like to say,
sure.
We live in such an isolated community very often, where people don't really interact in important ways. So I see diversity as a value from the standpoint of learning about each other and getting along. So it's not just the innovation and the creativity, but it's also just understanding what's different and what's the same. what are stereotypes that ought to be challenged.
I don't know how closely with the schedule you have you follow the Supreme Court, but there's a couple of important decisions still pending. Do you read anything into this decision in terms of what we might get on the same-sex marriage case, for example?
Yeah, well, I think that the court has clearly made a decision not to make a very formalistic equality approach, and that may bode very well in the marriage equality area as well.
So they weren't making waves here.
No.
Is that one way to look at it?
Yeah, I think that at least in terms of this opinion, Kennedy, the centrist, has really kind of occupied the field, and that'll be good. Who's to say who's going to actually write the opinion in the marriage cases? And in some respects, this court really reflects a diversity of views, and who writes the opinion may have a real impact on defining the law.
There's a couple minutes left. Let's focus on the law school for a minute.
Okay.
You've been the dean for a few years now. The school's 200th anniversary isn't that far away. Yeah. How are things?
I think we're doing quite well. We have a diverse student body, a diverse faculty. We have been engaged in a number of different very strong programs that are in the top 10 nationally recognized. Obviously, we are now the Carey Law School because of a substantial gift, and I'm looking forward to the future. Legal education is going through a real process of evaluation in terms of how we best serve our students, and the conversations that we have to have are tough. You probably also know that the enrollment in legal education institutions has fallen dramatically. So that challenges us to provide education that people are interested in and that will serve them for jobs.
Let's squeeze in a quick phone call. This is Charles in Baltimore City. Charles, thanks for calling. Go ahead.
Yes. My question is, I understand about affirmative action and its decisions by the High Court, but haven't they already done studies that have shown that there have been a number of students that have been precluded from enrollment in the schools whose places have been taken by, whether it was a racial or minority group, and they found that a number of students were not able to get enrolled into the
Charles,
school?
I just have a couple of seconds. Let me get a quick response.
Yeah, we don't have a seat-by-seat determination. We have a very large number of applicants, and there's no one seat that's committed to anyone. And particularly in law school, we're interested in a broad diversity of views and backgrounds and influences because we have to serve clients with those breadths.
Dean Phoebe Haddon of the University of Maryland Carey Law School, thank you for coming in.
Thank you.
Appreciate the time. Thank you for joining us for Direct Connection. We're back Thursday with Your Money and Business. For all of us at MPT, I'm Jeff Salkin. Have a good night.